Dear colleagues, ladies and gentlemen, the European Academy of Science and Arts, in collaboration with the Hellenic Blue Shield Committee and with the endorsement of the Hungarian National Commission for UNESCO and the academic partnership of the Heritage Science University of Ljubljana, warmly welcomes you to our international online colloquium on how new technologies, ethics, and global cooperation can safeguard humanity's cultural heritage in times of crisis. Today, it is the second colloquium coordinated by Professor Fran Solina, member of our academy, and the professor at the University of Ljubljana. Professor Boštjan Marko Turk, our moderator, had unexpected impediments and could not be the moderator. Professor Solina shall start inviting co-organizers and endorsees, if they are present, to greet this event and continue with the speaker and discussion. Dear Frank.
Thank you. First, I would like to welcome all the participants, and I would like to invite our president, Professor Mainzer, to address all the participants. Professor Mainzer.
Okay. Thank you so much again for this invitation. As president, it's my pleasure, of course, to bring you the greetings again on behalf of the whole Academy to this really remarkable series on the European heritage. And this evening we will hear a talk about on looting of antiquities and archeological sites. And I think that's really interdisciplinary again. And you know, interdisciplinarity is the profile of our academy, because the topic touches law, that is our class 5, and arts, our class 3, and humanities and cultural studies, that is our class 1. And looting and robbing antiquities, I think that is not only a question of law, but it also concerns and touches the psychology of people, the psychology and identity of a country. And therefore, it is necessary to have a background, not only in law to speak about this topic, but of anthropology, psychology, and even history. And I think that is nicely the case this evening with our speaker, Dr. Gerstenblith, who is not only a distinguished lawyer, I think a PhD Harvard, but also an expert, and she studies anthropology and art history. And that is again a wonderful interdisciplinary profile for this topic, and fits our profile of our academy. So I look forward to learn more about this topic this evening, and I wish us all an exciting discussion. Thank you.
Thank you very much. I would like to ask Dr. Elena Korka to address the participants and to introduce our speaker for this session.
Well, thank you very much. As this is the second colloquium of a series of colloquia which are organized by the European Academy of Arts and Sciences, I would like to congratulate the organizers once more again for this wonderful initiative. It brings close to many people, experts in the field, and Patty Gerstenblith is among the most prominent scholars in her field. I am very honored as the chair of the Hellenic Committee of the Blue Shield to endorse this specific topic which we're dealing with tonight. It is something that Greece deals with very strongly because it is a very rich country in cultural goods. And of course, it is strongly affected by looting and illicit trafficking. Now, concerning Patty, I must say that she is a scholar that I met in 1999 in a very important colloquium that took place in New York. She already by then was one of the greatest experts all over the world, and definitely the expert in the United States. Everyone referred to her, but she always kept such a low profile, never asking for any acknowledgement for all the wonderful studies that she has carried out. By now, she is, of course, the most prominent scholar in the US regarding the looting of and illicit trafficking of cultural goods. She is the chair of our working group in the Blue Shield International regarding illicit trafficking. The work she does is immense. Her knowledge is something which is unbelievable, and I think that everyone will really profit from her presentation tonight. Thank you so much, Patty, for being with us.
Thank you. We are really extremely fortunate to have with us Professor Patty Gerstenblith, a distinguished scholar in cultural heritage law and expert in cultural heritage and art law. She teaches at DePaul University College of Law in Chicago, where she is a distinguished research professor of law and director of the Center for Art, Museum, and Cultural Heritage Law. Here is a short summary of who she is and why she is notable. She specializes in cultural heritage law, focusing on protection of archeological sites, museum law, restitution of cultural objects, and legal issues around looted and trafficked antiquities. She has authored major works, including the influential casebook Art, Cultural Heritage, and the Law, and the book Cultural Objects and Reparative Justice. She has served in important public roles, including chair of the U.S. Cultural Property Advisory Committee, appointed by President Barack Obama, and previously as a member under President Bill Clinton. She was the founding president of the Lawyers Committee for Cultural Heritage Preservation and is involved in the U.S. Committee of the Blue Shield, which works to protect cultural heritage in conflict and disaster zones. Her academic background includes degrees from Bryn Mawr College, Harvard University, PhD in art history and anthropology, and Northwestern University School of Law, where she obtained a Doctor of Law. In short, Gerstenblith is a leading voice in international art and cultural heritage law, both in academia and in policy advising. Following her lecture, we will have a discussion session where you can ask questions or comment on the issues raised. I look forward to a lively and thoughtful exchange. Please join me in welcoming Professor Gerstenblith. Now, Professor Gerstenblith, you can start your lecture, and you can, if you could please share your slides for the audience. Perfect. Thank you.
Well, I want to thank you all very much. I am getting over a cold, so I may have to stop for a drink of water occasionally or two. my throat. But I want to thank the Academy, Ioannis, Liritzis for the invitation to speak. It's a great honor for me. Um, I really am overwhelmed by Elena's introduction. I'm so touched, and I wasn't exactly sure who she was talking about, quite honestly, but I was, as I said, I'm very touched by the generous words of for her and for Professor Salina as well. It is a great honor, as I said, for me to be speaking to the Academy, particularly because, as Professor Mainzer said, my topic is an inherently interdisciplinary subject. And so it is so appropriate to this group and to the Academy. It combines many areas of science, as I will talk about during my presentation. Not necessarily some high-tech aspects, although I tend to stay away from the high-tech aspects myself, but also art history, archaeology, anthropology, and of course, the legal sciences, and a little bit of economics even thrown in there. So we will get started, but as I said, I think that this is such an important topic, one to which I have devoted my life, and particularly in the pursuit of interdisciplinary studies and understandings. So I'm very, very pleased to be speaking with you today. So the looting of archaeological sites is a worldwide problem. This happens to be an aerial view of a site in southern Iraq. The image was taken in 2003. And depending on how good your screen is that you're looking from, you will be able to see looters on the site itself. And these are all looters' pits throughout the site as well. The looting of archaeological sites and then the trafficking of the antiquities that come from those sites, I suggest, is first of all a worldwide phenomenon. No part of the world is free of it. And that the primary motivation is economics, not the sole motivation. Some people like to take objects from the past and keep them for themselves. But by and large, the motivation for the looting of archaeological sites is so the looters can pass objects on to smugglers, traffickers, intermediaries for the objects to then eventually surface in intermediate market countries and eventually to the destination market countries, as we will see as I go through the presentation. And to show that no country is immune, this is actually a view of looters at a site in southwestern part of the United States. As is true of most countries, no one can monitor and guard every single site that is in their territory, and we cannot expect that. So the goal is to not just to protect sites, which obviously we want to do, but also to decrease the motivation and the benefits that come to the looters and the smugglers from the looting of archaeological sites. Sorry, I'm just getting a little used to using my screen here. So what is lost when an archaeological site is looted? And partly this depends on the scientific aspects of the understanding of archaeology. So in its most basic form, an archaeological site, and I'm using here sort of standard Mediterranean, Eastern Mediterranean sites that are built up over time through layers known as strata. And the study of archaeology is premised on understanding the stratigraphy of a site. So whether we look at a schematic drawing of a site, as we see in the upper left, a site in the Negev, this drawing was done by Sir Flinders Petrie in the 1890s, or a schematic view on the right of a site in Greece, site from the US on the bottom left, and a site on the bottom right, which is an actual picture of a site from which you can see the different colors of the different layers. It is by excavating a site layer by layer that one is able to establish the contextual relationship of objects, and not just saleable objects. It can also include architectural remains. You see over here a cross-section through the site showing a wall. So architectural remains, faunal and floral remains, all kinds of objects, and sometimes in burials, human remains as well. So from the proper excavation, where those intangible relationships can be understood and preserved, this is necessary to build our understanding of the past. Through that, a whole variety of understanding of the past is gained, be it from trade relationships, social hierarchies, economics, health, diet, artistic remains, all of that, literary remains can be recovered. Maybe not 100%, but that enables the fullest understanding of the past. When a site is looted, we lose that contextual relationship and the ability to understand our past. Other things are lost as well when a site is looted or other detrimental effects result. This is a site, again, an aerial view in eastern Syria, the site of Mari, dating from the late third and early second millennia BCE. Aerial view, this is a palace. The white structure here is a palace preserved from the late third millennium. Sorry, I'm getting my millennium mixed up. But this is before, as you see, from 2011. And this is a view of the site in 2014 after it fell under the control of the so-called Islamic State or Daesh. The red circles illustrate some of the looters' pits that were dug under the direction of ISIS during that time period. And you can orient yourself by the white roof of the palace there again. We know from evidence, not only from remote sensing, as with the image that I just showed you, but also through recoveries and other documents obtained during the conflict in which Daesh was eventually, if not defeated, at least diminished. And we know that a large quantity of coins, as you see in the upper left, ceramics on the bottom left, were looted under the direction or directly by ISIS. And these were eventually sold onto the international market. From Syria came particularly large quantities of coins and also cylinder seals, objects that are small, fairly durable, and easily transported and difficult to trace, as we'll talk about. I should say that when I talk about the science of archaeology, in its most basic form is the study of stratigraphy, as I mentioned. In contemporary archaeology, there are far more sophisticated forms of scientific research and analyses that are used. Everything from carbon-14 dating, thermoluminescence dating, flotation, remote sensing, all kinds of techniques are used. As I said, I tend to stay away from the hardcore technological aspects of more contemporary archaeology, but it's something to keep in mind. And that really is a connection where archaeology straddles the STEM fields and the humanities. So that already is part of that interdisciplinary study. So here we see that the looting of archaeological sites can help to fund armed conflict and terrorist activities. Also, we are gaining more information about connections between archaeological looting and trafficking with other forms, particularly of financial crimes. We know on the article on the left refers to a dealer, collector in objects from Cambodia, somebody named Douglas Lashford, who was charged. He died before he was actually prosecuted or convicted. But he was connected with various forms, or at least charged with, I should say, various forms of money laundering, fraud, mail and wire fraud, and use of things like offshore trusts and the like. Just in the past few days came out information from the Epstein files that Epstein was acting actually as an art advisor to a very large collector in the United States named Leon Black. Most of Black's collection is modern and contemporary art and valued in the many billions of dollars in worth. But it seems that Black also had a collection, not a large one, of objects from Cambodia, which, as the article says, he claims were acquired legitimately. I will not comment on that. But we see another possibility for connections between looting and trafficking in antiquities and different kinds of, I'll just say, problematic conduct. And last, but certainly not least, and this was referred to in the introduction, that when archaeological sites are looted, people lose part of their identity. Their ancient history, in many parts of the world, people have lived in the same areas for centuries and millennia. When sites are looted, they lose both their connection to their past, to their identity. They also lose a source of contemporary economic benefit for them. Archaeological sites are often, not always, but often become tourist attractions, and this becomes a source of economic benefit to the contemporary groups and societies that live near to the site. So we have this whole range of negative impacts, negative, we call them externalities, that a looter imposes on society. The looter does not necessarily realize those negatives, but society as a whole does. And the goal of the law should be to make, we call it, make the person producing those negative externalities internalize them, meaning we should, society, and as I'll talk about through the law, should impose negative internalities on those people so they stop doing that conduct which is harming society at large. Now, as I start to transition into some of the legal questions, there are a couple of distinctions that I need to make. First of all is a distinction between theft and illegal export. These are not always the same. So the theft is the taking of an object from its owner without permission. It is illegal and a crime in virtually every country that I know of, under national or local law. And as I'll expand on in a moment, I view this as two kinds of theft. One is what we call standard theft, which can apply to any kind of object, and then archaeological theft, which I will talk about in more detail. We also have illegal export. That's the taking of a cultural object from a country where the country restricts the export of the object. So taking an object without permission is illegal export. It is not always illegal to import an illegally exported object. So if an object is illegally exported from one country, it may still be legally imported into another country. And that becomes the crux of a lot of how the law has to fashion itself, develop particular legal principles to stop that kind of activity. But if somebody legally owns an object in one country, but takes it out in violation of an export control, it may not be illegal to import it to another country. Unlike a stolen object, if you take a stolen object, it's still a stolen object, even when taken to another country, with some, I have to admit, some variations out there. But the main point right now is illegal export is not necessarily theft. So I'll say a word about standard theft of cultural objects, because archaeological objects can be stolen just like any other kind of movable property. If they are documented, these are objects that are known and generally recorded as part of a public or private collection before their theft or illegal removal. And just as an example, this is an object that was stolen out of the museum, the National Museum of Iraq in Baghdad at the time of the US-led invasion in 2003. It was acquired not much long, just a few years afterwards by a museum in the United States and eventually returned to Iraq. Just another example of standard stolen property. These are sculptures that were excavated in Lebanon in the 1960s. These were known and recorded. They were put in storage during the Lebanese Civil War, stolen from there in the 1990s, and eventually surfaced in Germany and the United States. And these were eventually recovered in 2018 and returned to the National Museum in Beirut. But these were known objects. Eventually, they get tracked down and they can be recovered. The far more difficult type of stolen property is archaeological theft. These are undocumented objects, not known, not recorded before their theft or illegal removal. These are mostly looted from the ground, and I'm going to focus on archaeological objects because that's our topic today. So these are things that are looted directly from the ground. There are other kinds of objects, particularly indigenous or ethnographic objects, which may also be unrecorded. But these objects are unknown, unrecorded, undocumented, and they typically first become known when they cross a border, appear on the market, or perhaps in a public collection. They may be owned by a private collection, but on loan to a public collection. So it's very difficult to find and track these objects down. Yet, as you can see from this diagram produced by Interpol, and admittedly, these statistics are a little bit on the old side from 2020, actually. The chart was produced in 2021, includes 2021. You can see the relative size of the objects, the size of the market of illegal objects that are taken from archaeological sites directly, unrecorded. Those are the yellow boxes, versus those cultural objects that are the subject of common theft, ordinary theft. And those are the brown, the smaller boxes. So you can see how much larger is the trade, if you will, or the movement of these undocumented objects. I think there's a reason for that, which is that it's much more difficult for law enforcement or other legal action to be taken against an undocumented object. And therefore, it is more lucrative to a smuggler to deal with, or a looter, to deal with something that is taken from the ground and previously unknown, than to take something that is documented and known and therefore can be tracked down as simply standard stolen property. Now, we also have to think about the structure of the market for a moment in terms of then thinking about how the law should apply to it. So objects typically originate in parts of the world that are archaeologically rich. And these that are taken from the ground without permission, unauthorized excavation, are illegal for the most part in the countries where they are discovered. They are then frequently transited through countries. We call them transit market countries, which come in two varieties. This is a little bit simplified, and it has changed over time. So this chart is based on actually research that was done back in the 1980s, updated in 2006 by my colleague, Professor Morat Kursel. And I want to thank her for sharing this chart with me. So objects then circulate through the market through transit countries. One are geographically advantaged states. These are countries that are next door to the country that is where the object originates. It used to be, the classic example was objects from Italy taken to Switzerland. And I'll talk about that again in a moment. But it was very easy because of the large number of commodities that would pass from one country to another, that inspections, customs inspections and the like were not very exacting. So we frequently have objects that first go to a neighboring country. But the second category, that is probably, I should say, a little less true today, because it's very easy to move things by airplane, sometimes by container ship from country to country. They don't necessarily have to go through a neighboring country first. They often do, but not necessarily always. But the second type of transit market country is also important to think about. And here they're labeled art market states. But basically, they are states whose laws differ from other countries that enable the object to circulate through such a country and obtain a veneer of legality. This can happen, for example, for a country that has not adopted the kind of laws that we're going to talk about in a moment, particularly that has not ratified the 1970 UNESCO Convention. Also, countries differ in what's called the good faith purchaser doctrine. Many of you are, of course, from European countries. The civil law in the continental European countries will allow transfer of stolen title to stolen property to a good faith purchaser. Whether there can be a good faith purchaser of an archaeological object is another question that perhaps we can discuss later. But in the common law countries, particularly the United States, a thief cannot transfer title, no matter what, even to a good faith purchaser. So by passing an object through a country that either has not ratified the 1970 convention or recognizes the good faith purchaser doctrine, or the country will issue an export license for an object that did not originate from that country, that gives the object a veneer of legality. And so that when it comes to being imported into a market state, a destination market state, the object appears to be legal. And it is a real challenge for law enforcement to track down such objects and establish that they are not, in fact, legal. I should mention that as I move through my legal examples, I'm not drawing exclusively on the United States, but we do have to recognize the United States now accounts for, I think it's 43% of the international art market. Second and third, very close to each other, are China and the UK. Those three countries together account for, I think it's close to 70% of the international market. It's actually a little more than about 75%. So looking at what a couple of countries do can have a big impact, I believe, on the market overall. So now, as I said, the goal, we can look at how the object moves from the archaeologically rich country through the transit markets to the destination markets, but we can work our way backwards in terms of incentives or disincentives by trying to impose negative consequences on the people at the end, because the people at the end in the destination market countries are the people putting money into the market, which then encourages the looting. You know, the money works its way backwards through the middlemen and eventually to the looter on the ground. Obviously, the looter on the ground realizes the least amount of financial benefit. But if the purchasers at the end of the market chain are discouraged because they may lose the value of their purchase, then the goal is to decrease the amount of money that is put into the economic system and thereby decrease the incentive for the looting itself to take place. So one way in which we impose those negative consequences is by enabling the recovery of these undocumented archaeological artifacts. Obviously, in the right situation, one would also want to see criminal prosecution of those involved, although criminal prosecution is much more difficult. In particular, because a criminal prosecution, I should say, in a destination market country, because the government would need to prove that the person knew or intended to handle stolen property. And that mens rea requirement is often very difficult to establish at the criminal level of proof. But there are basically three mechanisms of recovery of objects. One is if an object is illegally exported and then imported into a market country, contrary to implementation provisions of the 1970 UNESCO Convention. And I'm going to talk about each of these three in more detail. Second, if the object is subject to what's called state or national ownership, then its removal makes it stolen property. Its removal without permission makes it stolen property. Third is that those first two legal doctrines encourage importers to improperly declare the objects, which becomes a third basis for the government to seize an object. So we have to think not only about these three bases, but how they essentially work together. So the first I'm going to talk about is the 1970 UNESCO Convention. Long title, you see it all up there on the screen. By the way, you're welcome to take pictures of any of the slides that I'm showing. I should have probably said that sooner. I've had some interesting debates with colleagues of mine as to which is the most important part of the UNESCO Convention. It is my belief that Article 3, which makes the import, export, or transfer of cultural property contrary to the provisions of the convention illicit. And most, I'll mention this in a little more detail in a moment, most market states implement the convention through reciprocal import restrictions. Switzerland requires an additional bilateral agreement, as does the United States. But the United States' implementation is even more restricted because it operates under Article 9, which applies only to pillage of archaeological and ethnological objects. I should mention, because I don't know how many of those listening are international lawyers or not, an international convention by itself, particularly a broad multilateral convention like the 1970 convention, applies only to a country after a country has ratified the convention or in some other way joined the convention. And very important, in most cases, the country, the ratifying country, also enacts implementing domestic or national legislation. It is that national legislation that defines the obligations under the convention. So we don't really look at the convention per se for its effectiveness and what can be done under the convention. We have to look at each country's national implementing legislation. It's one of those things that's not very popular to talk about, but necessary. And as we'll see, particularly the United States, and I would suggest the UK, and perhaps even China, have in their national implementing legislation adopted very narrow or meager provisions for implementing the legislation. But I'll come back to that in just a moment. So, my apologies. Okay. So, as I said, most state parties implement Article 3, which means it applies to a very broad range of cultural objects. And they do so through what I call, well, not just me, others call reciprocal import restrictions, which means that if something is subject to export restriction under that country's implementation of the 1970 convention, it becomes illegal to import into the other state party. And I've put up here 3 countries' laws. Again, you're welcome to take a picture of it if you wish. Canada, Germany, and France. Germany and France only adopted their implementing legislation in this form in 2016. Canada's goes back to the 1980s. Australia goes back to the 1980s. The Netherlands. So many of the bigger and smaller market countries have adopted this basic provision. And if I just read the Canadian law, it is illegal to import into Canada any foreign cultural property that was illegally exported from that reciprocating state, meaning another country that has ratified the 1970 convention. Very simple, very straightforward. It applies to every other country that has ratified the convention. We're now up to, I think, almost 145 countries that have done so. And if a country changes its export restrictions, that will automatically have an effect for an importing country. Unfortunately, there's really 3 exceptions to this. The UK, when it ratified the convention, did not adopt specific implementing legislation. It does have a criminal provision, which has not been used in the international context. But 2 other countries worth looking at: Switzerland, which used to be a primary go-between, transit country for objects such as from Italy, ratified the convention in 2005, operates under Article 3, so that broad category of cultural property, but requires this additional supplementary bilateral agreement, which it currently has 9, and you can see the list and the dates, and you can see some of the returns that were done pursuant to these bilateral agreements. You can see the example of Greece from 2011. But 9 is really a very small number, given there are about 145 state parties to the convention. So that's something, if you're from a country not on that list, consider approaching the Swiss authorities for such an agreement. Now, the United States also requires an additional bilateral agreement. It's extremely complicated how these come about. The Cultural Property Advisory Committee in the State Department that was mentioned in my introduction reviews countries' requests for these agreements. The United States currently has, and I always add this up wrong, but it's 31. We've just added one about 2 weeks ago for Nepal, just joined the list. And we have emergency import restrictions for 5 countries that you see. Those are the countries in yellow, and then green is Syria and Iraq, for which the U.S. has special legislation. I'm really sorry. One of the problems is that these agreements need to be renewed every 5 years. And I'll mention, since Elena is here, that the agreement with the Hellenic Republic is up for consideration right now. And there will be a meeting of the Cultural Property Advisory Committee, I think, in about 2 weeks to consider that renewal, along with Egypt and Bolivia. The fact that these agreements may not be renewed is a problem in terms of really providing a disincentive. And we have 2 cases where the agreements were not renewed. One was Canada and the other Nicaragua. So I would suggest that the U.S. system is really problematic because there's always a chance the agreement won't be renewed and it would become legal to import these objects into the U.S. and thereby not really providing as strong a disincentive as we need. There's a lot, as I said, that's very complicated about these agreements. I'm happy to go into them in more detail if there are questions later. You see here, this is just the official notice of the agreement with Libya that was extended not too long ago. But these agreements work with what's called a designated list, which is somewhat similar to how the ICOM red list, some of you may be familiar with, where objects are listed by type, not specific objects, but a category or a type. So if an object that is previously unknown fits into one of those categories, then it is subject to import restriction into the U.S., depending on when it left its country of origin. And this is just a few. I would say the United States has returned easily tens of thousands, if not more, objects under these agreements, which the oldest of which now go back 40 years. But this is just on the upper left, example from El Salvador, examples from Cambodia, and on the bottom right, examples from China. But, I mean, tens of thousands, if not more, objects. Some countries have also entered into cooperative agreements, usually under Article 9 of the 1970 Convention. And these agreements do not have the force of law so much. They're just these 2 countries will cooperate. There are many, many of these agreements out there. China alone, I think, has 20 or 30 such agreements. And these are just examples of objects returned through those cooperative agreements. One between Jordan and Egypt, another Argentina and China. Okay, the second major legal principle that has been developed to deal with undocumented archaeological objects has to do with national ownership. Many countries that are rich in archaeological heritage have adopted laws that vest ownership of undiscovered archaeological objects in the nation. When those objects are removed without permission and taken to a market country, they are categorized as stolen property. And then our standard general law prohibiting trade, possession, import, etc. of stolen property applies. This was first recognized in the United States in the 1970s, involving artifacts taken from Mexico, but was reaffirmed in a very important decision in 2003, involving, in the center here, and this is actually the same piece. It's a sculptural head of the pharaoh Amenhotep III. that was a New York dealer was conspiring with a British conservator to import this into the United States, along with several other objects. In this case, the dealer was actually convicted and went to prison for intending to handle stolen property. But we have several other cases. This case on the bottom left also involves the prosecution and conviction of a dealer for dealing in objects from Egypt. He was actually convicted for fraud, not for handling stolen property, but Egypt was able to recover the objects that had been taken from Egypt. In the center on the bottom is a case from the UK involving objects taken from Iran. That's a civil recovery case where Iran came into court and recovered its stolen property. And that recognized the Iranian laws establishing the Iranian law from 1979 as establishing ownership. And over on the right is an object that was taken from Turkey. Turkey went into court to recover it, lost on a different basis, but at least the trial court recognized the 1906 Ottoman decree as establishing ownership. And many countries' laws, Elena is here, so she will correct me if I'm wrong, but Greece's law goes back at least to the 1930s. Iraq's law goes back to the 1930s. There may be older laws as well. Egypt's laws probably go back before 1983. So these objects and the laws that vest ownership in the country become a basis for recovery, either in a private suit that the foreign country brings or by the national government of the country where the object is located, and I'll come back to that in a moment, or in a criminal prosecution as well, depending on the exact circumstances. The idea of national ownership has been used recently. Some of you may be familiar with the New York District Attorney's Office that has established an anti-theft unit and has recovered many millions of dollars worth of artifacts. You see on the upper left something from a New York collector named Michael Steinhardt, who gave up $70 million, or according to the New York DA's office, $70 million worth of artifacts. And on the center bottom, a series of sculptures that were returned to Turkey that were taken from a site called Buban, which private collectors, several museums and private collectors throughout the United States have now returned these objects. And these are all premised on the idea that these are stolen property. So many times museums and collectors will give the objects up without litigation because they will recognize that these things are in fact stolen. The third basis, as I mentioned, is improper declaration. Importers will declare a different country of origin in many cases because they want to evade scrutiny from the customs agents. In this case from 1999, which established this principle, this gold bowl had been looted from Sicily, passed through Switzerland for a few hours, and was misdeclared upon entry. The country of origin was stated to be Switzerland, and it lost approximately $1 million off of its declared value. This was recovered by the US government and returned to Italy. And an example from the UK, this is a sculpture that had been looted from the site of Cyrene in Libya. Again, its country of origin was misstated, and its value, I think about $2 million, was cut off its value. This was forfeited by the UK government and returned to Libya. And the last case I'll mention, involving, some of you may have heard of the Hobby Lobby Corporation in the US that has acquired a very large collection of antiquities from various countries. Perhaps the largest single recovery and restitution from the United States involved these collections of objects. These objects were violated all three principles. They were imported in violation of the US's implementation of the 1970 Convention. They were considered stolen property under Iraq's ownership law, which goes back to the 1930s, and they were improperly declared upon import. As I said, resulted another object from that was also, went too fast there. Also acquired by Hobby Lobby, the Gilgamesh Dream Tablet from southern Iraq, dating from about 1600 BC, a very important ancient cuneiform document. These were all forfeited and returned by the United States government to Iraq. You'll see here, this is boxes of 17,000 objects. 12,000 were recovered by the government. 5,000 were given up voluntarily by Cornell University. And on the bottom right, you see the Gilgamesh tablet back in the Iraq Museum in Baghdad. So this is one of the largest, if not the largest, repatriation that took place at one time from the US, and illustrates, as I said, all of these different legal principles together. And with that, I thank you for your attention, and I'm happy for the discussion that will follow.
Thank you very much for your presentation. And now, please, we have plenty of time for questions and discussion. Professor Mainzer?
Yeah, thank you very much for this very impressive talk. I have a question from a more general point of view of law. This topic this evening concerns people's law and international law. And you know, in politics, in the moment, since perhaps some months, we have the impression that people's law and international law is under pressure. That means the international discussion is dominated by power and not so much by considering the international and people's law. Now, how much has this tendency now in politics an influence to your topic? I was surprised, and I was impressed that it seems to be that your country, the United States, have a lot of moves with many countries to come to a good solution. And now my general question: what is the tension between the international law now and people's law with these very concrete questions concerning looting archeological values?
Okay, thank you for that. I will try to that's a big question. I will, if I leave something out, or feel free to follow up. And I will also try to be politic as opposed to political. But I guess there are two things that I would mention that are challenging for us in the US working on cultural heritage preservation. The first, which is a very practical matter, a lot of our laws depend on, and the effectiveness depend on US government law enforcement. The New York District Attorney is separate, but their jurisdiction is limited to New York City. Really, it's limited to Manhattan, the island of Manhattan. Of course, that's the center of the art trade in the US, but it's still somewhat limited jurisdiction. A lot of the government's, the federal government's customs enforcement, I will say, has been diverted to issues, particularly immigration. So I would guess, or it appears, and I can't, this is a, intuitive impression, that there may be somewhat less on the law enforcement side. It doesn't change the basic underlying law, but there may be less enforcement for a time period. Doesn't mean it can't come back later. I think the other problem, and maybe in some ways the bigger problem, those MOUs that you meant, the Memorandum of Agreement or Understanding, they're very political. in an international political sense of, what happens if there's a country that wants to have or has an agreement and it's coming up for renewal. Arguably, this is probably what happened in Nicaragua, that the relationship between the United States and Nicaragua wasn't so great. And so the diplomatic relationship that you need to have these agreements, and you do have to have a diplomatic relationship for an agreement. My guess is it was not renewed because, of bad relations between the U.S. and Nicaragua at the time, if that makes sense.
Okay.
I'm being told the sound is not stable. I don't know if it would be better if I use my earphones or not. So my concern about these agreements is, as they come up for renewal, will the U.S. decide not to renew them because of its view of international relations? So far, we have renewed every agreement in the past few years. The Nicaragua example is from the late 2010s. I can't remember the exact year. The Canada agreement was not renewed back in 2002. So long predates any of our current political issues. The one thing I will say is the U.S. government seems to like bilateral relations as opposed to multilateral relations. And so the memorandum of understanding, which are bilateral agreements, I don't want to jinx anything, but they seem to be okay for the time being, and we hope it will stay that way. If an agreement is not renewed, that has a very serious consequence and not one that can be easily fixed in the future.
Thank you.
Sure.
Thank you. Next is Professor Mitchell, please.
Thank you. I hope you can hear me, but I typed my question in the chat to be sure that it's understood. It's a very short question, but it may be complicated to answer. What do you mean by Libya? If I'm correctly informed, it's very unclear whether there's a functioning state in Libya at this time. So how can we know whether the objects returned there are safe?
There's actually two parts to that question, I guess. When an object is returned, particularly to the extent it's a government that's doing the return, it's up to each government, whether it's the UK or the US or whatever, to decide who they recognize as the government of a particular country. It's clear we recognize that Libya exists. And when you return something, it's state to state, it's government to government. So it would be returned to whomever is the government. But in the case of Libya, at least from returns from the United States, there have been returns to Libya, Yemen, and various other places that are a subject of ongoing armed conflict. What has often happened recently in the last several years, title is transferred to that government, and the government of the other country has loaned the object back. I'm sorry I didn't show an example of it, but there was a sculpture that the Cleveland Museum returned. There have been returned to Libya. There have been examples, as I said, from Yemen, both with the Smithsonian and the Metropolitan Museum in New York. These objects have been loaned back, so they do not physically move. Title transfers. They are now owned by the foreign country. Foreign country lends them back, recognizing they may not be in a position to take care of the object at the moment. But it is up to the country to decide. And when we say, are we sure it will be protected? We can never be sure whether an object is protected in any particular country, including the market country where it's currently located. We've seen examples of museums, archives, libraries in all different countries that are subject to, if it's not armed conflict, then fire and other kinds of natural disaster. I don't think any of us, when an object belongs to somebody else, be it another country or a person or institution, not for us to set limits on what should go back, and what that country can do with it. It is really there to, it's no different than if, I often use this example, I do not have a alarm system on my house. I don't. If somebody comes in and steals my TV set and then the police recover it, and the thief says, well, okay, it belongs to Patty, but I'm not going to give it back to her because she's negligent because she doesn't have an alarm system on her house. Does anybody actually think I wouldn't get my TV set back because of that? Well, I don't think it works that way. So, I mean, obviously, cultural objects are more important, more significant, unique compared to my TV set. But nonetheless, when stolen property is in the hands of somebody, maybe not the thief, maybe an innocent purchaser, nonetheless, I don't think that we can set limits or, you have to jump through this hoop. You have to do a certain thing before I'll give you back your stolen property. So that's a mindset that I think we need to change. I hope I answered the question. There were a lot of parts to that question.
Just points to the distinction. It just points to the distinction historians well know between the written constitutions and real constitutions.
Thank you for the question and for the answer. Now, next question will be posed by Professor Tassos Buntis.
Thank you very, very much for this very clear and illuminating talk on some very subtle issues. I wanted to ask about relationship between the US and Mexico and other countries in Mesoamerica concerning Mayas and the temples there. Has there been any looting in that direction? Are there some such marvels from the Mesoamerican cultures brought over to some US museum and exhibited there?
Okay, I'll start by saying I'm not an expert in Mesoamerican culture. If you asked me that question about the Mediterranean, I'd be better qualified to answer. My PhD was in Near Eastern archaeology, so but yes, the answer to your question is yes. There was large-scale looting of Mesoamerican sites in the 60s and the 70s. And if you work in the Mesoamerican field, you probably know Dr. Clemency Coggins, or her name. And she wrote a very influential article in 1969. She was also on the U.S. delegation to the that was in the drafting of the 1970 convention, I should say. She wrote a very influential article in 1969 about the dismemberment of pre-Columbian architecture, temples, and the like. And the U.S., in fact, passed a law in, I think it was 1972. So before the U.S.
So recent, yeah, so recent.
No, but older than when our implementation of the 1970 convention, which is 1983. So we passed a law in 1972, I think, which prohibits the import of pre-Columbian monumental sculptures and murals. But quite a lot had been acquired by U.S. museums before that. But then Clemency Coggins made an interesting point that the U.S. legislation on that, which applies to, architectural, stone, sculpture, monuments, etc., simply moved the market away from those to smaller objects, particularly ceramics, which then were looted on a large scale, which is as destructive as looting the large pieces. Whether you take a small thing or a big thing out of an archaeological site, it is equally destructive to the site itself. And that, I shouldn't say it led to, but our implementation of the 1970 convention, which has some similarity to that earlier statute, applies to everything archaeological. It's not limited to the monumental sculptures. I should say the question I thought you were going to ask me is we don't have, if you notice the map, we don't have an agreement with Mexico for a variety of reasons. But I will say that the U.S. recovers a large quantity of Mexican materials under the recognition of Mexico's ownership law, which I believe is 1972 also. The criminal prosecution from the late 70s for dealers conspiring to deal in ceramic artifacts taken from Mexico means that we have very strong, the law enforcement very strong in preventing the import of objects from Mexico into the US. And for whatever reason, well, Mexico was very unhappy about how the US implemented the convention and actually does not regard, or in the past did not regard the US as a state party to the 1970 convention because of it. But we rely instead on national ownership or improper declaration upon import. But the area of the southern border of the US, which of course now is being very well monitored, also leads to the recovery of archaeological artifacts. And they're not all necessarily from Mexico. People will bring things from different parts of the world and bring them in through Central America, or try to bring them in from Central America and Mexico into the US as well. So.
Yeah. Has there been any return to Mexico?
Yeah, thousands of pieces. Oh yeah. More of the ceramics, I think, but some examples. There was a voluntary return quite a while ago of murals, I think from Teotihuacan, from a museum in San Francisco. But a lot is still in U.S. museums.
Murals, you said. Murals.
Murals, yeah. Well, sculptural reliefs, I think.
Yes. Thank you very much.
Sure.
We have still time for further questions. I would like to ask you, are there, in addition to legal and institutional safeguards, is technology increasingly invoked as a tool for protecting cultural heritage? So in light of these recent advances of, for example, artificial intelligence and so on, what do you think the prospects are of using more technology for protecting cultural heritage?
Right. Great question. And I'm going to be a little, I guess, of a skeptic here in some ways. And it goes back to that basic distinction between documented and undocumented objects. With respect to documented objects, there's no question that technology can help. And that one of the key elements, and this is something that Elena Korka and I and others have talked about, in preparation to protect your collection. If you're a museum or a private collector, the most important thing you can do to protect your collection is to document it, and document it, really carefully with images that show the object from several sides. So inventories are crucial to the later recovery of objects. A collection that has been properly documented, which is very time-consuming and difficult to do, and is definitely a place where I think technology can obviously help. And then if you have a huge, let's say, database of everything in a museum, and something is picked up by law enforcement, sure, you could use some kind of, again, I'm not a technology person per se, but you could certainly run an image against the databases that exist and find out, was it stolen from a documented collection. That's not necessarily new, but as technology improves, you can do all that faster. You can handle larger quantities of images. So you can do an image match. The challenge, as with all of this, is the undocumented object, because you have nothing to match. And if law enforcement picks up an object at the border and they want to know, is it stolen, is it legal, whatever, they have nothing really, no database to run it against to find a one-to-one match. Is this object something stolen from a collection, known and stolen? But I will say that when an object is picked up at the border, and law enforcement is trying to decide, is it legal or not? Was it properly declared? There are always two first questions that need to be answered. First of all, what is it? Or two parts to the same question. What is it? Where is it from? Because its legal status almost always depends, in the first instance, where was it dug up? Where was it first discovered? Because it is the law of the country where it was first discovered that, for the most part, applies either under national ownership or under the question of illegal export and import. Intermediate countries don't matter. It's the country of origin. And for an archaeological object, that is the country within whose modern borders the object was discovered in modern times. So we need to identify what is it and where is it from? And then the second question is it authentic? So far, by and large, experts are used to make both of those determinations. But that can be very time-consuming and difficult. So one question is trying to figure out how can modern technology, how can AI technology help in identifying, at least at that basic level, what is the object? Where is it from? Is it authentic? So that the expert's time, which takes time, and law enforcement doesn't always have that amount of time, so that at least an initial identification can be made by comparing an object maybe to other databases out there or something like that. But other than that, I would say I don't think technology is the answer. I would love it to be the answer. But for the unknown object, it's very difficult. I mean, there's also the idea of tagging objects, which can be done again, but that has to be a known documented object. It's the unknown, undocumented object that's the challenge.
Thank you very much. Any other questions, please?
Can I ask one question, Dr.
Yes.
Professor Beris?
Go ahead.
Do you hear me?
Yes, we hear you.
Professor Beris, Faubert. Fotis Beris.
Okay.
Yes.
We hear you.
Yes. My question is the following. In the previous colloquium, I think 15 days ago, we spoke a lot about England and Greece, about the Parthenon and the British Museum. My question is, first of all, do we consider the sculptures of Phidias that are in British Museum as a theft or as illegal export? Number one. And number two, what are the relationships concerning all these, let's say, rules for returning the sculptures back to Greece?
Okay. Do we have another 2 hours? Okay. I will say that I started off, my undergraduate degree was in classical and Near Eastern archaeology. And at that time, we were taught, so this is a long time ago, how the British, how Elgin saved the marbles from all sorts of things, whether it was the Turks or from Athenian air pollution or all those kinds of things. So I have gone through a long journey over more than 50 years to finally come to my own sort of thoughts and conclusion about this. From a strictly legal perspective, it's very hard to answer because there's a lot of information that we don't really have. It's unclear exactly what the Ottomans gave permission for Elgin to do. It seems fairly likely that actually he was not given permission to take the sculptures off the building and take them away. But we don't have the original document. It's hard to tell. I heard part of the program 2 weeks ago, but I then had to get on a plane and I didn't hear the second part of it. But there's been a lot, and I know Elena was at a conference where this was discussed about, 3 or 4 years ago, I think. There are different scholars who have tried to go back and study the original Ottoman documents, and as far as I'm aware, have not discovered them. So we don't really know what Elgin was given permission to do. There's also the question of whether the Ottomans had the authority to give permission. I mean, in contemporary terms, we would look at what is today Greece as occupied territory. And even that early in time, if you think about the end of the Napoleonic Wars, when the French were forced to return objects to the places from which the French had taken them, and that's just about the same time period. It's not clear that the Ottomans really had authority to, you may be familiar with the work of John Henry Merriman, who was a very prominent American international law scholar, and he wrote about these issues as well. He definitely took the view that the UK had the right to the marbles. But I think that I think the purely legal question is a difficult one, and a lot that we don't know and we'll probably never know. As I said, we'll never probably know exactly what Elgin had permission to do. Was it up to the Ottomans to give permission? I know my answer is kind of rambling here. What was the extent of corruption involved? Because it's clear that Elgin or his agents paid off the local authorities, bribed them essentially to let them take the sculptures away. And there's also the argument that, too much time has passed, that Greece should have sued sooner if they were going to try to do this as a legal matter. My answer tends not to be a legal answer because of all of these uncertainties. My answer is based more on the integrity of the site, of the building, the intent of the original artists. I mean, it's clear that the artists did not intend the building to be dismembered. It is clear that Elgin did a lot of damage in the process. We think of him, well, some people think of him, and as I was taught, that he saved the sculptures. No, he didn't save them. He destroyed an awful lot in the process. And whenever I personally look at the sculptures sitting in London, I always think they must be very cold. They're sitting inside. They should be outside. They should be under the Athenian sky. They should be part of a large monumental sculptural program that had an intent, unifying intent, as an expression of 5th century Athens. Pericles' program, Phidias, Ictinus, all of them had this vision. And it's true that the sculptures can't, because of Elgin, to a large extent, cannot be put back to where they belong. But nonetheless, if you go to the museum in Athens, the relatively new museum, not so new anymore, you can see how they are still part of that single, not just even architectural and sculptural and artistic, but also the geographic, topographic location. It clearly all belongs together. And so as a historical matter, as an art historical matter, I do believe they should be returned. Not purely as a legal question, but as a humanistic question, historical question. And I would say that people who do the wrong thing should not be allowed to benefit from it. And there were a lot, I did hear the part of the lecture 2 weeks ago that talked about the reception of the marbles in the UK. It was questioned from the very beginning whether it was legitimate, either legally or more morally. So I come down to it as a moral, historical, artistic conclusion that they should in fact be returned.
Thank you very much for your answer and also for your position, because we think that, first of all, the two skies are not the same. today in Athens, we have a beautiful blue sky. And second, we believe that when a sculpture is in the place where the artists have decided to put it, then the sculpture speaks to you and gives you some arguments and also some messages. And I'm sure that the message that we have from the British Museum is a message of cry and a message of of sorrow, not of happiness, and they are looking for their friends and their brothers and sisters. We hope that the day will come when all humanity will celebrate the reunification of the marbles, because this civilization is our civilization, at least in Europe and in the United States. How many buildings have used as a model the Parthenon in order to do it in a modern neoclassic way? Also, really, thank you very much for your talk. Excellent, very clear. I learned many things, and also for your conclusion that you believe that we must not separate something that we have the chance to have almost more than 90% saved. Thank you very much.
Thank you.
Thank you. Do we have any other questions?
If there is any other question, I
Yes,
have to
Liritzis.
thank you, Patty, for your excellent illuminating lecture, very clear. And I thank all of you for your presence, and to remind you that the next third one, colloquium, is on Friday, 16th of March, with the title, Can One Pose as David of Michelangelo, or Should Italy Ask for Fees? The Protection of National Cultural Heritage. Thank you very much for your presence, and hope to see you next time.